Hi, everybody. Harry here to talk about the latest developments in the increasingly complex landscape of the 14th Amendment, Section 3. So, the big event, of course, has been Colorado and their holding of the Supreme Court based on the factual record created by their trial court that Trump is not qualified to be on the ballot. And I think you're also aware that Maine did something similar in that the Secretary of State, who's the officer responsible for initial challenges, made a similar holding that now has to go through the courts. But we now have Illinois and Massachusetts. Just today, there's launching of similar challenges, kind of like Maine, because they are initially done at the administrative level and they would go on to their state courts. So they wouldn't be, and Maine wouldn't be, making its way to the Supreme Court anytime soon. Nevertheless, it's as if they're already there. Indeed, the petition by Trump to the Supreme Court in Colorado actually mentions Maine. But the reason is the court already, I think, was acutely aware, and now all the more so, that they are, in the Colorado case, contemplating much more than Colorado, contemplating the prospect that either in the primary or more seriously in the general election, the ballot in some states list Donald Trump, the likely Republican nominee, and in others, it doesn't. We've talked about this before. You know, there'll be law scholars writing about it for years. And it seems to me it's all kind of a vestige of the odd amalgam of state and federal power that our system at its founding provided for the choice of a president. And it's not all shown itself to be well adapted to the present day, but it's the Constitution we have. Nevertheless, while I think this kind of arrangement wouldn't have put the founders out of joint, it will put the Supreme Court and our modern day political system out of joint. In other words, whatever the constitutional allocation of power, we culturally, politically, practically see the presidential election as a national election, and having it go forward with a nominee for a major party on some ballots and not others, I think will be anathema to the Supreme Court. So it's an amazing time for the court. There are no fewer than 3 cases that could have huge implications for Trump. And so, you know, the sort of braiding together of law and politics is almost a singular event in constitutional history, but no more than this, because the immunity question, the question of the interpretation of the obstruction statute presented in one of the January 6th cases, but with real implications for Trump, those are can be handled in everyday fashion. It's not 100% clear that the Supreme Court needs to weigh in, and it's not 100% clear that it deeply implicates Trump's prospects for being convicted, especially since I think it's likely the court will find no immunity. Colorado and 14th Amendment Section 3 are different. Right now, there might be many ways to strike down Colorado, but several of them would permit other states like Maine, like Massachusetts, like Illinois, and there are several others where things seem to be germinating to have this patchwork quilt to keep Trump off the ballot. And the Supreme Court, which, you know, would love to have nothing to do with any case that could completely alter a national election, just can't let this stand, it seems to me. So this is upwards of 95% that they take this case. And indeed, it's moved incredibly quickly. So just we're taping Friday. On Wednesday, the winners below responding to Trump's and the Republican committees, they're both parties below, petition for cert, said, yeah, go ahead, grab it. They disagreed about the questions presented, but they said, yeah, Supreme Court, go ahead and grab it. And the next day, so yesterday, Thursday, the Trump team came in with its reply brief, and everyone's saying, grab it, and do it quickly. The reply brief takes a little bit of issue with how the challengers in Colorado present some of the legal landscape, especially the idea that Congress, the claim that Congress has the power and the sole power to decide who is disqualified under Section 3. That's going to be a major claim in front of the Supreme Court, but pretty much it just says, yes, go for it. Again, a competent reply brief from Trump, nothing great, but certainly not the kind of trash that he's filed in different places. This is, lawyers have been permitted to draft this and to serve it up to the Supreme Court. So the briefs are all in. The Supreme Court's next conference where they could consider this afternoon, Friday, January 5th. And typically, if they were to grant cert or whatever they do on a Friday, they let us know on a Monday. Here, they could actually let us know this afternoon. That would be the first sign that the court is wanting to move at warp speed. So they're going to first consider this. And I just think this is such a unusual case for the court. And, the obvious kinds of questions people are asking is, will the court be political? And I think what they mean by that is, will the Trump people want to vote for Trump to win and the progressives want to vote against Trump to win? I think they will be political, but in a different way. At least the sort of critical mass of justices, they will want to be thinking of the result. And as I've suggested, I think the result they'll want to be thinking of is one uniform federal solution. You can imagine, in some universe, that federal solution would be, we find that he is disqualified under Section 3 of the 14th Amendment, but I don't think in this universe. Among other things, they don't really have the tools to do it, and they know that would cause an unbelievable howl and outrage that they just simply lop him off that way. So I think the uniform solution they'll be looking to impose is one where he remains on the ballot everywhere. And they'll want to do it in short order. Just how short? A regular case could take a year and a half to kind of from the time they receive the petition to when they decide it. In the Nixon case, which is somewhat analogous, they boom, did the whole thing in a couple months. In Bush versus Gore, where they had these, deadlines looming of certifying the election and the like, it was even quicker. And so the question will be, will the court be focused in particular on March 5th, Super Tuesday, and wanting to give some indication before Trump's nomination becomes a fait accompli, or will it be adequate for them to take enough time, and surely it's a case that could benefit from that, deliberation, so that Trump remains on the ballot in the general, but they're not going to play such hurry up to focus on March 5th. We'll have a better idea if and when they take it. I'm going to say when they take it, which could be as soon as today. And in particular, what will they say? This is one dramatic point that is in the immediate horizon, and they have different options on. What will the so-called questions presented be? What will they say are the questions they want to address and answer? The Republican committee offered 3. And the winners in response said, do the first 2, but not the third. The 2 that they are suggesting are, 1, is Trump an officer within the meaning of the provision, because it doesn't specifically list president, and 2, essentially, it's a little more nuanced than this, but is it up to Congress to decide who's disqualified? And then the third had to do with his First Amendment rights, Trump's, and the respondents came in and said, that's really not important. It's fact-based. You can't really decide that anyway. You don't have it in front of you. But the first 2, they matter, and decide those 2. And those two, it does seem to me, are their two best candidates for a uniform federal rule. Trump, for his part, in his petition, which he filed after the Republican committee, just says, did Colorado get it right? He does one question presented. That question would permit maximum flexibility. The parties could come in and give 8 reasons why they got it wrong and 8 reasons why they got it right and go through the whole thing. And the court could very possibly leave it open-ended to just that extent and really prompt something of a free-for-all in the arguments in the court and in the briefing. So that will be the next kind of dramatic point. So the two things that will A, tell us something, and B, be very important in the case and issue itself will be, will the Supreme Court take the case today or at their next conference, which, in other words, within a week? And what will the questions presented be? Then we'll take it from there. As I've said, this is, a case where they really wish it would go away, but it won't. And there will be, at least John Roberts hopes, a kind of consensus across political lines for doing something that speaks firmly and almost certainly in support of the position that Trump stays on all the ballots. There are some not very good, kind of bad boys and girls on the court, and in particular, Alito and Thomas, who don't seem to give a fig about making the court seem divided and issuing impassioned dissents and the like. So that's a worry. They'd really prefer not, and Roberts would, for that not to happen, and they'd really, really prefer for this not to be a 6-3 along so-called party lines. So the court will be, as I've said, thinking more broadly than it normally does in other cases, thinking in terms of a uniform solution and very much hoping, does Roberts, and probably will have some support, say from Kagan, Kavanaugh, on different sides of the aisle, for a result that doesn't make it look as if the court has just, parachuted into the middle of election and put its substantive thumb or political favoritism thumb on a scale and isn't deeply divided. So that's, I think, will matter more than the actual solution that they seize on. Okay, so keep an eye out, and things are happening fast. Maybe we hear from the court as soon as today, but probably soon. What questions will it present, and how fast a briefing schedule will it set up? That'll tell us quite a lot about what their focus is, and even about their likely reasoning when they do issue the decision. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.